Meanwhile, the National Industrial Court has issued an interim order restraining the Nigerian Labour Congress, Trade Union Congress and 3 others from embarking on any form of industrial action or protest. Justice Emmanuel Sibilim, ruling on an ex parte application filed by the Minister of the FCT, Wike, and the FCT administration, granted an interim order restraining the 1st to 5th respondents from embarking on strike pending the hearing of the motion on notice. He also ordered the 5th and 6th defendants who are security agencies to ensure no breakdown of law and order. The ex parte motion, which was filed by James Onoja San on behalf of the minister and the FCT Council, FCTA rather, the chairman of the FCT Council had sent a message of mobilization to members and affiliate unions for a mass protest scheduled for 3rd February. The court adjourned until 10th February for hearing. Well, let's talk to our judiciary correspondent, Celestina Area, who joins me live from Abuja. It's the second intervention we are getting from the Industrial Court in the FCT. Walk us through how this ex parte motion are gotten and what it means for the unions at this time.
Well, Nifemi, we recall that on the 27th of January, the Industrial Court had ordered that workers return to court and suspend the strike because of the application filed by, or the suit rather, filed by the FCT minister and the FCT administration. And the suit, as the courts found, it's as a referral, which when a referral is being made to the Industrial Court in terms of industrial action or dispute, such protest or such strike should be halted. But in this very case now, the respondents in that particular suit that was filed by the FCT minister were just 2 persons, which is the president and the secretary of the Joint Union Action Congress or Committee. And when the order was given, there were speculations that the order was not binding on all the workers because those 2 persons who were respondents were there in their were not there in their capacity as president and secretary. They were just there as individuals. So the order were not binding on all the unions. And also their lawyer had tried to join NLC and TUC in the application, but the court said that is not right for hearing. But we also could see that some workers did not comply or did not obey the order of the court. And from the ex parte application that was moved today, the claimant, which is the FCT minister through his lawyer, James Onoja, Senior Advocate of Nigeria, has said that there is a planned protest scheduled for 3rd of February, which is tomorrow, and that protest is in contravention or contravenes the order of the court or violation of the order of the court, which refrained the NLC, JOAC, NLC, TUC from engaging in any form of protest or industrial action. So now the order is explicit. It covers all trade union, and the court has said that any planned protest should be put on hold pending the determination of the motion on notice brought before it. So the court adjourned to 10th of February for hearing. Right. So what it means now, we now have 2 cases before the court.
Well, I guess we'll wait to hear how the unions react to this. Let's talk about the other case you covered at the High Court, the arraignment of 9 suspects for the Yawata killing in Benue. The court refused an oral bail application and scheduled a formal bail hearing for 26th of this month. Explain what the next steps are now in this trial.
Okay, very well. After arraignment, usually the prosecution will move to call its witnesses and also ask that the defendants be remanded in a safe place, and in this particular instance, in the correctional center. But the counsel to the defendant had stood up to say that he wants to orally move an application for their bail, and Justice Abdulmalik noted that the practice in her court, the application for bail cannot be done orally, that he should file a proper formal application for bail before the court so that the prosecution would have an opportunity to respond by also filing his objection, and if there is need, he replies on points of law. So the court asked that he file his proper bail application for the prosecution to respond, and we also know that the prosecution team was led by the Attorney General of the Federation. Nifemi, you also recall that last year, which was just a few months ago, the news of killings dominated major headlines to the point that it became talk in international communities and meetings. So this is very important for the AGF himself to be in court to ensure that due diligence is done and the trial commences in earnest. He also asked for a celebrated hearing in the case so as not to delay proceedings.
Well, we're talking about the AGF's presence. What's the significance of the Attorney General personally leading the prosecution in this case? What does it signal about federal government's approach?
Okay, if we go by the criminal proceedings that have been ongoing from last year to this very moment, we've seen cases of terrorism cases coming up quite often, and most of them are being prosecuted by the Department of State Services, the DSS, and also the DSS are also prosecuting some cases related to this Yawata case, and they arraigned the suspects in August. But we also recall that the AGF usually puts out statements to tell Nigerians that whoever commits acts of terrorism or connive to commit any act of terrorism will face the wrath of the law and will be brought to justice. And this, for him, it's a move to let Nigerians know that he's not just in his office issuing fiat to agencies to prosecute. He, as a lawyer and also as a senior advocate of Nigeria, was also into litigation before he became the Minister of Justice, and also as Attorney General of the Federation. He can also go to the court and also lead prosecution and also take charge of cases.